So for today's topic, we have chosen mastering wills, trust, and incapacities. And the reason being, we have been asked a lot about it. So if you have any questions while we are giving this presentation, please put your questions in chat and we can answer them once our presentation is over. And if we are somehow not able to have time, we will send you an email detailing response to your questions. So let's just get started with the agenda of today's meeting. Uh, Talking about few scenarios we have seen in the past and giving very basics of what and why estate planning is important, but also talking a little basics about the wills, trust, and incapacities. So let's get started with a little information about myself. I'm a dual qualified attorney from India. I'm a daughter, mother, sister, lawyer, and I'm a dreamer. I'm a dreamer, but as any other Indian is, we have had a vision and we are here because we have somehow met it or in the process of meeting. Uh, I am a dual qualified attorney, as I said, and I practice estate planning, immigration, business, and real estate. I have 18 years of work experience, and my mission here is to help clients educate and understand the day-to-day legal intricacies and help them solve them. So our first case scenario is Raj and Meera, who moved on work visas, on H-1B, L visas, and they bought a home together. They have a joint bank account and they're raising two kids. But one day, Raj, who was the primary H1 bread earner, passed away and there was no will or trust. So my question is, what do you think happens next? What happened next was that as soon as H1B expired, the spouse has to leave. There is no way that the spouse can stay over except if somebody supported in creating that tourist visa in time. With the current scenario, we have very limited time to process that. And if we are not timely, we are in that state of chaos of being illegal and then being in the deportation, right? So most of the times people think, okay, let's leave. We don't want to be in that illegal zone where the US system can take action. But what happened is that there is no will. So there is no decision on assets. Even if there was will, the will needs to be taken to the court. But because, I mean, the spouse is not here. So there is nobody who can take that will in the court and request for distribution or beneficiary. Now, if there is no trust, then there is no automatic way of going away from probate. Probate is the court process through which the will gets authenticated. But if we have a trust, we can bypass the probate. So there is no will and there is no trust. And there are no emergency documents because they did not do estate planning. So now who will be the guardian of their US born kids? That's a big question because there is no automatic guardianship in US. And most probably those children are going to go to child support services in temporary foster care system while the juvenile court decides how the guardianship is going to take place. We have another scenario where Michael and Sarah both are US citizens. They both live in Washington and they have two young children from previous marriages. So now we are talking about two children who are step children to the parents, the alternative parents. But again, they did not create a will or create a trust or even name guardians, right? And if both the parents pass away, now it's a very different kind of flux because there is no automatic inheritance for a child from a step parent. Moreover, if in this scenario just one parent passed away, even then for the stepchild, there is no automatic guardianship. All these need to be nominated and accepted. And because in this scenario, Michael and Sarah never thought about it, now both these children need to go through the child protection services, but also for their estate, they need to go into court and fight it out. And now there needs to be a division of the assets these parents jointly own because only the stepchild has right to inherit their share of their parents' uh, estate. So it's a more complicated scenario which people have not thought about, or they are yet to understand that something like that can happen. Now we again, there are no appointed guardians, probate, delays, and if for any reason one side of the children do not claim anything, then Washington State unclaimed property is currently sitting at $2 billion. So we don't want to add to it. We want to make sure that we can protect our assets from going there. Now, there's one totally different scenario where both Raj and Priya are US citizens, but they don't have any heirs here, and all their family, their nieces, nephews, their parents are in India. So now we're talking about overseas assets and how can somebody even think about, like in India, for an example, it's a taboo to talk about inheritance or how much I own or what my wealth is. People think we are kind of showing off, but the reality of thing is if nobody knows what assets we own in US, then when we are gone, and if for any reason we don't have a clear will demarcating what assets we have, then there is chances of, you know, either them not being able to receive any of the funds because they need to hire a US attorney to even understand how the US inheritance or US estate system works. Two, there is taxation barriers. If any assets transfer from US to India, they need to understand how that taxation works. We don't want to lose 40 to 50% of our assets just because we did not think about it. And now 50% of them it is lost because of the taxation. Then again, anything which your family does not understand you own goes into unclaimed property. And we don't, again, want to add to the $2 billion. So I talked a lot about, what happened. But let's very clearly and in simple words understand what estate planning is. A lot of people come to me and say, hey, estate planning is for wealthy, or, how do I'm not dying, so why should I think about it? Or wouldn't the court make the choice for me? Wouldn't that be the right thing? And my answer to this is estate planning is for anybody and everybody. If you have any assets more than 100,000, if you have family, if you have children, if you have beneficiaries, you want to give money to your friend, somebody who supported you, and you really feel that you want to take care of them, then all that can be done only through planning. There is nothing automatic. Nobody can understand your mind. It has to be written into words. And that is important. And that is done through estate planning. Now, court can make decisions, but how do you make sure that they make the decisions you want for guardian for your children, or how your money should be divided or given to various entities, or what happens if you are alive but due to medical reasons or some other reasons you are not able to make your decisions? That also is part of estate planning. Now, court can make decisions, but how can we make sure that the court will make right decisions? And the second thing is, for court to make decisions, somebody has to go to the court. And if your family does not know about it, or if your family does not have that 6 to 24 months worth of financial support, which is needed, because till the time the court does not decide that those assets go through to the person you have nominated, those that assets are stuck for waiting for the court decision. So if you don't think you have that rainy day money secured for 6 to 24 months, it's a bad idea to write a will and think that, oh, everything will pass through the court order. Now, again, when we were talking about it and we're saying, okay, why estate planning? One, we want to secure our kids, our family, and our inheritance. We want to make sure that the money which we have earned through all our hard work and labor is for the people we want to give. We did not earn it for the state. We did not earn it for a court to take attorney fees or something, right? We or for IRS to take it as taxes. We earned it for our family, and we want to make sure when we are gone, this money can be utilized for taking care of our children, or for their college tuition, or for them till the time they're financially dependent. But unless and until you write it, until you have the legal documentation available, this is not automatic. The second thing is we want to avoid conflict. Now, conflict could be anything, like conflict could be among people who think they can be beneficiaries, or conflict could be how the court interprets what you have written versus what you really wanted. We want to avoid any conflict. And that's why it's really important that we plan all our assets. The third thing is peace of mind, right? Life is uncertain. COVID taught us very clearly that nobody's an immortal. Life can change tomorrow. So, what is the only thing which we can be assured of is how we have planned for our loved ones when we are gone. And that peace of mind comes with estate planning. Now, most of the times people confuse between a will and a trust. So let's just do a very quick run through on what will is and how it works. Will is a legal document in which you write how you want things to be divided or distributed, or guardianship of your children, like all those in a written document. Nobody validates what is written in the document. The only validation through witnesses is that you were of your right mind and that nobody pressurized you into writing what is written. And you and the two witnesses notarize that in front of a notary. And what the notary is authorizing or authenticating is just that you three are the people who claim to be those people, right? The notary is not responsible for authenticating that you have the assets, what you have mentioned there, that your family members' names have been written correctly, nothing. So if you want to distribute something, that validation is not happening. If you want to name some guardians, you have named it. But as no authentication has happened, when you pass away, the legal process is required to authenticate that. And why it is required? For multiple reasons. You might have written a will today, 5 years later, you had children, you wrote another will. But you never said, oh, my previous will is off. No, I'm canceling my previous will. So now we have two wills. So there's a battle of the forms which will control. Or we have written some assets. Somebody needs to validate that this is your last will. Somebody needs to validate that these are the assets which are there. Somebody needs to validate that the people you have named are the right people who are claiming those assets. And that is the whole court process, which is called probate. Now, probate can take anywhere from 6 months, if it's a very simple will, to 24 months, depending on where the beneficiaries reside, if they're overseas, if somebody contests it, if somebody conflicts it, all those things can pull it even beyond 24 months. But in general, we have seen 6 to 24 months is what it takes for a will to be probated. But again, somebody needs to initiate the probate, and you have to pay the court fees, you have to pay the attorney fees, you have to pay everybody before your assets are released. Because till the time the will is not probated, those assets are stuck where they are. Now, how a trust works. Now, trust is a very generic term, but what we mean by trust here is a revocable living trust. And we call it revocable because during your lifetime, it's fluid. It only gets registered when one of the spouses passes away. So let's just say, in simple words, it's kind of a will, but when one spouse passes away, you don't need to go through the court process. You just register the trust with IRS, and then within 3 to 6 months, the trust can start paying all the beneficiaries, or it can start administering your assets as you have written in the trust. Now, why trust is important? The trust is private. A lot of the time people say, what do you mean by private? Well, a will, as soon as it go to the court, is a public document. And when something becomes a public document, there are a lot of eyes on it. But we don't want a lot of people to look into it, especially if one of the spouses pass away. We don't want somebody to come after the surviving spouse's assets or target that person, right? So we try to, and we want to keep it a private document. Trust ensures that privacy. The other thing is, as we discussed, the court process can be very long, time consuming, money pinching, and disheartening because you're talking about the same thing again and again. Now, trust bypasses probate, trust bypasses the court system. And the third thing is that trust is the only way you can make sure that the assets are distributed in a gradual manner versus if you write a will, the court will distribute those assets at that point in time. So, an example is if I want to give money to my children for education when they turn 18, but they are currently 15. Now, the court is not going to say, oh, you know what, we are going to keep this money for 3 years before your kid turns 18. They will say, oh, we will appoint this guardian, and the responsibility of the guardian is to take care of this money. Now, how financial savvy is the guardian? Is it a court appointed guardian or a guardian which you nominated? It's all court's discretion, and that's something we want to avoid. So, in a nutshell, what the will is simple but goes through court. All decisions are public. Anything written in the will still needs to be decided by the court. It's court's interpretation. It can take anywhere from 6 months to 24 months. The assets are disposed at that point in time. So there is no way you can guarantee that those assets are given to your children or given to your family members in a more installment manner. And at minimum, you need to make sure that, you need to go to the court and the court will distribute your assets. Now, when we say trust, again, it's revocable living trust, and it's more complex to set up because we are putting all the rules and guardrails to avoid going to the court to make it very automatic for it to maybe be controlled within its own environment. So it's a little complex to create, but once it is created, it's it's more easy to monitor and it's more easy to keep up with. Now, the second thing is privacy, as we said, that we want to keep our assets private, and will is a public document versus trust. The third thing is tax planning. There are a lot of things, and especially when we are a visa holder or a green card holder, we have to think about, okay, what is our federal estate tax and what is the Washington state estate tax? Now, these are two different parameters, and depending on where you are, they have a very big tax threshold, and only trust allows us to do tax planning, whether the assets are transferring from the deceased spouse to the surviving spouse, or the assets are transferring for the deceased parents to the minor child. Both of those segments, tax planning and even advanced tax planning, if you're high net worth and you have a lot of life insurance, real estate, and assets, you can do tax planning through a trust, which is not available otherwise. Now, revocable living trust takes 2 to 6 months to set up, and that's only the administration time for your attorney to work with whosoever is your successor trustee to setting it up with IRS and to make sure that all the reporting of your last income tax and the first reporting of the trust is completed before those assets can be transferred. Again, we can make sure that in the trust you talk about your children or your children's children or even a charity. We can plan all that within a trust. And trust is a must for families with minor children or overseas ties because it's very difficult for children or for our overseas families to navigate through the US legal system. The other thing which nobody is talking about is incapacities. Now, we don't have to pass away for the estate planning to work for us. If we are not able to make decisions, if we are physically or mentally are incapacitated, or if there are any limitations, we are traveling or we are unavailable, then these documents help in making those decisions. So, healthcare power of attorney is really important for making decisions if you are not medically available to make those decisions. So it's not automatic that your spouse can make decisions, and it's not automatic that your sister can make decisions. All that needs to be written in a legal document and notarized. Same for financial power of attorney, especially it comes into play if there are hospital bills to be paid from your accounts, then this financial power of attorney helps into make those decisions. Now we can make this healthcare power of attorney and financial power of attorney both immediately available so that whosoever has it can make decisions. But especially when we are doing estate planning, we make it springing, which means if you have incapacity, which is proven by either your spouse and a doctor or two medical professionals, then only those power of attorneys can be used. Otherwise, they are inactive or dormant. We need HIPAA authorization for anybody to be able to look at your medical documents. Living will is very prevalent nowadays because most of the times we have seen a lot of our income goes into medical bills. If we have not put in our tab on, we don't want to be on artificial life support. If the doctor has already said that no life is there, right? And if insurance has already said that they will not cover it, then all those expensive medical bills are getting paid from your assets before the plug is pulled. So we write a living will to say that if there is no life and if the doctors have said that no life can be sustained, then we don't want to be on artificial life support. And the final thing is guardianship documents. Guardianship documents are really important for minor children when we are talking about temporary guardians, where if you are not available for the first 60 days, Washington state allows you to have guardianship, and permanent guardians for somebody who you want and trust to take care of your children. Now, when we start talk about estate tax, let's very lightly and gently touch on it. Now, the federal exemption for 2024 was 13.6 million, but now it's actually 15 million with the new big beautiful bill. It's now 15 million for federal tax exemption, and in 2025 July, Washington state has also updated it from 2.2 million to 3 million. But those are like the big dollar amount tax exemptions. Again, the federal exemption changes if you're a visa holder versus a green card holder versus a US citizen. So the 15 million, the bucket is only available to US citizens. And if there is no tax treaty, then of course there are chances of double taxation. So we also have to be careful about that. So as we discussed and we have seen through examples, if there is no plan, assets can be lost as unclaimed property, children have no protection, and there are higher chances of them going for foster care or child protection services. If there are no decision makings, then the court decides for you and there is no privacy. Any court proceeding is a public document. Now, why guardianship and emergency planning matters, especially with with minor children, child custody is our most important concern. And until and unless we have temporary guardians named or permanent guardians named or both named, our planning is incomplete. Now, temporary guardian, anybody who has a document can use it within the first 60 days without needing a court. But for permanent guardian, court process is required. But it's really important that there is temporary guardian in place because then that temporary guardian can take custody of the child while the process is going on. So there is no requirement of child to go through that foster care system. So we are always thinking, what will happen to my child on the first night? Generally, what happens? The paramedical will come, they will call police will take the children in custody, and then they will go to the juvenile court. Juvenile court will put them to child support services and temporary foster care till the time they can make decisions. But the child in all this process is the one who's the most affected, and we don't want that to happen. So that's why emergency planning is important. Now, as we said that, Washington lets you nominate temporary guardians, and my general rule of thumb is at least 3 to 5 people who are 30 minutes away, 30 to 1 hour, right? So that if somebody has the information that this has happened to the family, they can be called, and the police, instead of sending the children to foster care or starting the juvenile process, can call you and give the custody of the child to the person who's nominated as temporary guardian. Permanent guardian is a totally different thing. It has to be started by the court, and the name list you give is only discretionary for the court, because the court has to decide that the person who is nominated is of good moral character, has ties with the child, and can take care of the child. So again, temporary 100%, the way you nominate them, that's how it would be used. Permanent, a little discretionary from the court, but it's better than not having a list at all. Also, the court prefers blood relations. So if you are naming family members, then it's always a good idea to name them in the permanent guardianship versus the court appointing its own guardian at law. So that was my presentation, and I hope you understood most of the concepts. But if not, feel free to reach out to us. I'll open the forum for questions.